Hello, great people. Welcome back to Global Happenings. Today, we're so excited to have you again. The issue between Wike and Fubara is really escalating because right now they have been able to drag in the judiciary, and from all indication, things may get worse day after day based on what has been coming out fairly recently. Now, the breaking news is that there is a leaked draft of an already written court ruling of the Federal High Court 8 Abuja for an Exparte application yet to be filed by the Pro-Wike former lawmakers, yet set to be delivered tomorrow. Immediately they complete the filing to pave way for commencement of the impeachment of Governor Fubara. Now, the recklessness of judiciary will set this country on fire. Judiciary must be controlled. Don't forget that even Agbagoba, who is the senior advocate of Nigeria, wasn't given an opportunity to talk during the 61st birthday of Godswill Akpabio during his lecture colloquium, talked about the recklessness of our judiciary, and we're still seeing this. Now, I'm going to read out this draft to you so that you get to hear exactly what they intend to do. Don't forget that before now, there had already been an order from a court in Rivers State, High Court in Rivers State, restraining them. Now they have gone as far as Abuja. I don't know what we are to expect. Now, according to the draft leaked out, it says that, and I read, it said, in the Federal High Court of Nigeria in the Abuja Judicial Division, holding at Abuja on Monday, the 18th day of December 2023, before His Lordship, the Honorable Justice D.U. Okorowo, suit number FNC/ABJ/CA/1681/2023 between all the DCAM lawmakers in the House of River State House of Assembly, and versus the Independent National Electoral Commission. That the first defendant, second is People Democratic Party, the third defendant is River State House of Assembly, fourth is the clerk of the River State House of Assembly, fifth is Inspector General of Police, and the sixth defendant is the Department of the State Services, DSS. And it really does, it said, by this urgent application, the plaintiff stroke applicant are praying this honorable court for 5 interim injunctive relief. I have carefully listened to the submission of the learned senior counsel and also considered the affidavit of Right Honorable Martin Chike Amewole, the first plaintiff, in support of the motion. The documentary evidence marked Exhibit A1 to A5 for A5, B1 to B5 and C, as well as the written addresses in support. He said the urgency of the subject matter on this suit is abundantly clear from the affidavit evidence and the supporting document. This court is eminently vested with the requisite jurisdiction to consider the application of this nature in the circumstances having regards to the provision of Order 26, Rule 5 of the Federal High Court Civil Procedure Rule 2019, which fact was strenuously emphasized by the learned senior counsel. The duty of the court to intervene is really urgent. I take that again. He said the duty of the court to intervene is in really urgent situations such as this is not in doubt. He went further to say that in Azul versus Union Bank of Nigeria PLC 2004-14 NWLR.893402 at page 415D to E, the Court of Appeal Pe Aminu JCA held that if a situation like the present one arises and a court is satisfied that a delay caused by the proceeding in the ordinary way would or might entail irreparable or serious mischief, the court may make an order ex parte on such terms in the court as the court may deem fit. Now, a perusal of Exhibit 1A to A5, from A1 to A5, shows in unmistaken terms that there is indeed crisis, deep division, and faction within the second defendant, as the PDP, leading to struggle for the leadership and control of the party. These crises and faction within the PDP has culminated into various conflicting interlocutory injunctions as exemplified by Exhibit B1 to B5. Evidently, this crisis and faction have led to the consideration of merger with other political party as shown in Exhibit 5. This court cannot ignore the import of Exhibit A1 to A5, B1 to B5 and C, which have affected the legal right of the applicant and necessitated them to find refuge by defecting to the All Progressive Congress APC. In the circumstances, there is urgent need to protect the seat of the plaintiff stroke applicant from declared vacant by the defendant or being hampered in the performance of their legislative function for which the electorate voted them. A timely intervention of this court is necessary, just as held by the court Pe Aguntaye JCA, as he then was, held the case of Attorney General of Anambra State and 9 ORAs versus Abo 1992, page 510FG, that says that laws do get broken. A vigilant person does not wait for irreparable steps to be taken against them before he takes preemptive action. Consequently, this motion is granted as prayed. For avoidance of doubt, an interim order of injunction is hereby made, restraining the first and the third defendants either by themselves, their officers, servants, agents, staff, or privies from declaring vacant or taking any step whatsoever to declare vacant the seats of the plaintiff's applicant of the Rivers State House of Assembly, from withdrawing the plaintiff's applicant's respective certificate of return, and from conducting fresh election to file in the seat of the plaintiff's applicant at the Rivers State House of Assembly, pending the hearing and determination of the motion on notice. 2. That the first defendant from conducting fresh election to fill in the seat of the plaintiff's applicant in Rivers State House of Assembly, pending the hearing and determination of the motion on notice. The defendant, jointly and severally by themselves or their servant, agent, official, officers, staffs, delegates of other persons deriving authorities from them, from interfering with or peddling in any way or attempting to interfere in any way the performance of the plaintiff official and legislative function as the Speaker, the Deputy Speaker, and members, irrespectively, of the Rivers State House of Assembly, pending the hearing and determination of the motion on notice. The defendant, jointly and severally by themselves or their servants, agents, officials, officers, staff, delegates of other persons deriving authorities from them, from interfering with or peddling in any way or attempting to interfere with or impede in any way to full enjoyment of the official rights and privileges of the plaintiff's applicant as the Speaker, Deputy Speaker, and members, respectively, of the Rivers State House of Assembly, pending the hearing and determination of the motion on notice. The fifth and sixth defendants by themselves, official, subordinate, servants, or agents, from denying or refusing to provide security for the plaintiff or howsoever withdrawing their security details or personnel, or failing to provide adequate security for the plaintiff's applicant for the purpose of enabling the said plaintiff's applicant to continue with the performance of their constitutional, legislative, and oversight function as the Speaker, Deputy Speaker, and members, respectively, of the Rivers State House of Assembly, and or from taking any adverse security measures or step, whether shapes such steps may be capable of preventing or obstructing the plaintiff or applicant from performing their function and duties as the Speaker, the Deputy Speaker, and members, respectively, of the Rivers State House of Assembly, pending the hearing and determination of the motion. The fifth and the sixth defendant by themselves, officers, subordinate servants or agents from denying or refusing to provide security for the plaintiff, or however withdrawing their security details or personnel, or failing to provide adequate security for the plaintiff stroke applicant for the purpose of enabling the said plaintiff stroke applicant to continue with the performance of their constitutional, legislative, and oversight function as the Speaker, Deputy Speaker, and members, respectively, of the Real State House of Assembly, and or from taking any adverse security measures or step, whether shape such steps may be capable of preventing or obstructing the plaintiff stroke applicant from performing their functions and duties in the Speaker or as the Speaker, Deputy Speaker, and members, respectively, of the Rivers State House of Assembly, pending the hearing and determination of the motion on notice. The motion on notice to which the interim order of injunction relates is hereby adjourned to Wednesday, the 17th day of January 2024 for hearing. Honorable Justice D.U. Okorowo, presiding justice. I mean, this is really, really serious. I must say sorry for some of the things. Maybe you didn't hear it well, but to tell you what it's sending out as a message, that's the conclusion of the whole thing, is that they are not to be stopped from functioning as speakers, deputy speakers, members of the House of Assembly, and they are not meant to be prevented from carrying out their oversight function, their constitutional, legislative functions, that they are not to be hindered. Oh my God, this is really serious, and Nigerians have really reacted. Someone here says Federal High Court in Rivers State have an order. Another Federal High Court in Abuja is giving an order. Why should Abuja Court be meddling in the affairs? And that's the big question. Why should Abuja Court be involved in what is happening in Rivers State? If they have already given some instructions, why didn't you want to come in? That's one thing that I don't really understand, but from all indication, it means that if things are not done the right way, the future of the Rivers State may be very, very bleak. That's what we'd like to leave it. Let's read in our comment section. What's the standpoint in respect